Okay, good morning, everyone. Welcome to Collier County Court. I'm Judge Martin. We've got one matter at 11 o'clock this morning, which is Ritchie versus Byrd. Can I get plaintiff's counsel's appearance, please?
Yes, Judge Thomas Gorman from the Law of Style and Day on behalf of Mr. Ritchie, who is also present, seated next to me.
Okay, good morning to you both. And I've got Rick's A71. Is that Mr. Byrd?
Yes, ma'am. Good morning.
Okay, good morning. All right, let me do this. Let me have Mr. Ritchie and Mr. Byrd. Would you both please raise your right hand? Do you both solemnly swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Where'd you go, Mr. Byrd?
I was trying to grab my Bible.
Do you swear?
Yes.
Okay, very good. You all can put your hands down. Everybody's been sworn. Okay, so this is an eviction matter brought by Mr. Ritchie against Mr. Byrd. I know there have been a number of filings, particularly by Mr. Byrd, and I set this hearing for really two purposes. One is that the plaintiff has requested a final judgment, and two, the defendant has asserted that he should be protected under the CDC eviction moratorium. And I have not had hearings with any of you gentlemen so far, but I've had dozens and dozens and dozens of others. And it is this court's interpretation of the CDC moratorium that a declaration may be filed, but that plaintiff may put a defendant to the test in terms of having an evidentiary hearing and asking defendant to testify. Also, plaintiff has an opportunity to testify as to whether the protections should be in place in this case based on the facts and circumstances for Mr. Byrd. So we're going to hear about the CDC, and this is how the flow chart works. At this point, just a quick recap, Mr. Byrd was served with the suit, and he answered, and I immediately did an order. In my order, I noted that plaintiff still had one base to tag in order to complete the service because service was done by posting, and plaintiff immediately did that. My order to pay rent was done the same day as defendant's answer, which is 4/21. Mr. Gorman then immediately did a certificate of mailing the next day, 4/22. That meant that under the statutes, an answer was already done, but rent was not paid. In order for Mr. Byrd to stay in the contest, he would have had to pay the full amount of the rent that I set forth in my order by the close of business 4/29. That's 5 business days after the date of the certificate of mailing. Mr. Byrd did pay the full amount of the rent from my order, $2,400, a day late. He paid it on 4/30. The law in Florida is extremely clear on that. It is not forgiving of 1 minute or 1 penny being late or short. So it was paid in full, but it was paid late. Under Florida law, without the moratorium, this case would be over. Mr. Byrd would have already been out. I would not have required a hearing of Mr. Gorman. I would have signed the final judgment because the law would have required me to do that. So Mr. Byrd is, to be clear for both sides, Mr. Byrd is in default. What the CDC says is that he may be in default, but he can nevertheless be protected from actually being removed if he qualifies for the protections. And Mr. Byrd, you've cited a lot of stuff that doesn't apply. You've cited the order of a colleague in Sarasota. They have chosen to take things differently there, but that's not our circuit. That chief judge doesn't have jurisdiction here. So all that this court has to do is evaluate whatever Mr. Byrd and Mr. Ritchie present in terms of evidence on the CDC declaration. If I find that Mr. Byrd is deserving of the protections based on the legal criteria of that moratorium, then he would be protected from removal through the end of the moratorium. Right now, that is June 30th. That may or may not be extended. And Mr. Gorman, the way I've been doing those, some landlords' attorneys have wanted me to do a final judgment, but just hold back the writ of possession. I don't like delegating the interpretation of the law to the clerk or the deputy who serves it. So I have a pile about this thick of final judgments that I have held, and I will be signing all of those on June 30th if there's no extension, and the writ of possession will issue immediately from those judgments. Do you follow me, Mr. Gorman?
Yes, Judge, we understand.
So that is Mr. Bird's best case scenario at this point. He will be evicted. He is in default. He does not have a legal avenue to contest the eviction, but he may today have an avenue to postpone it. For Mr. Ritchie's standpoint, if I find that Mr. Bird does not satisfy the CDC, then Mr. Ritchie would be entitled to a final judgment immediately, today. And Mr. Bird could be removed as quickly as tomorrow. So as we sit here right now for the parties, there's about a 7 week swing between best case scenario and worst case scenario, depending on which angle you're looking at the case from. Part of the reason I belabor that point is I don't want to sneak up on anyone. I'm fully prepared to hear the evidence and I'll make the call. I have, before hearing the evidence in every single one of these hearings that I've had, once I sort of set the table, I have asked the parties, do you all want to have a conversation to see whether there is any middle ground available to you? And let me tell you what I mean by that. An awful lot of people have found middle ground. The landlord's disaster would be, I've got to house this guy for 7 more weeks and I haven't been paid any rent. The tenant's disaster is, I've got 1 day to get out of here. And the happy medium that could theoretically be carved out by agreement is, we're going to pick a mutually agreeable date, and that'll be the deadline for Mr. Bird to get out. As long as Mr. Bird does get out on time, there'd be no eviction. You would avoid the scarlet letter, if you will, of having the eviction on your record, because it makes it very difficult to get another place to rent. If, on the other hand, Mr. Bird misses that deadline and doesn't move out as agreed, Mr. Ritchie would get an immediate judgment, and the CDC would not be in play. You'd have an immediate judgment because you made an agreement outside of the CDC. So it can be attractive to Mr. Bird because even though he missed the statutory requirements and he is right now teed up for a certain eviction, it's only a question of when, he could actually avoid that eviction by making this agreement. And even though Mr. Ritchie right now faces the possible reality of having to house Mr. Bird till June or possibly longer if the federal government extends it, he gets certainty, he gets a guarantee that he will have an eviction if the deal is not honored. Because I know there's been some back and forth about, well, you said you would do this and then you didn't do that. This would be a judicial agreement. There would be no wiggling on the deadlines. So having said that, let me turn to you first, Mr. Gorman. I gathered from some of the filings, there's been some discussion, but none of it came to fruition. Do you all want to take a moment? I can put you in a breakout room so you can speak freely and frankly out of the presence of the court and see whether there's any date that could be agreed upon or any other terms that could be agreed upon? Or do you all want to just have the court hear the evidence and make the call here?
Judge, we've made some efforts to try and do that, but I'm always willing to make additional efforts, Judge. So okay. Why don't you put us in a brief breakout room for maybe 3 or 4 minutes, Judge? I don't think it's going to take long. It's either going to come to something or not, but it's worth a try. Why not?
Mr. Bird, did you understand everything that I had sort of gone through in terms of reciting the history of the case and also describing what the legal landscape is, what your outcomes are here today?
Yes, ma'am, I do.
All right. Are you amenable to letting me just have you guys have a virtual face-to-face conversation to see if there's any middle ground you can find before we go forward with the hearing?
I'm fine with that, Your Honor.
Let's do that. I'll set up the breakout rooms and have you go there. And I'm just going to again reiterate and encourage both sides. The idea of a compromise is both sides give up something they want, but both sides also get something they want. And so I encourage you to work to try to see if there's middle ground. If Mr. Ritchie says, yeah, I'll give you till Friday to get out, well, that's not a whole lot better than Mr. Bird's worst case scenario, and that wouldn't be a thoughtful compromise. And if Mr. Bird says, yeah, I'll get out in August, well, that's not a real attractive offer for Mr. Ritchie. So both of you are going to have to try to think something between tomorrow and June 30th is really what you're thinking of. And I encourage both sides to do your best to be reasonable and understand the other side's challenges, and maybe get something done. So I'm going to open these rooms. You're going to have, Mr. Bird, you'll have a little invitation on your screen there. Just accept it and you'll be in a private room. Speak freely. Neither side is allowed to tell me what the other side says in settlement discussions. It cannot be used against you. So speak freely, roll up your sleeves. Let's see if you can get something done. And if not, I'll see you back in the courtroom. Good luck.
Thank you, Judge.
Court will be in recess. Okay.
Yeah.
Go ahead, Mr. Gorman.
Yeah, Judge, we reached a proposed resolution. I don't know if you want me to outline the terms for you right now or what?
Sure. Go ahead and tell me what you all have agreed to, and then I'll confirm that Mr. Byrd agrees with your synopsis.
Okay, so essentially, Mr. Byrd, his daughter's graduating from high school on the 28th. We have agreed to give him to the 29th, the next day, to move out of the room, upstairs room. And in exchange for that, we've agreed to split the proceeds that are in the registry of the court. So essentially, Mr. Ritchie would receive $1,600 and Mr. Byrd would receive $1,600 upon his leaving on the 29th. If
that's assuming, I think that's assuming another $800 gets paid.
Yeah, Judge, we agreed to, this was going to cover everything, Judge.
Okay, because I've only got 2,400 in the registry, so.
I know, Judge, but we're talking 2 weeks, and we've agreed to accept this as total.
Okay.
For everything. So. Okay.
I don't know if we're communicating though. You're splitting a registry of 3,200. At the moment, it's only 2,400. So is there also a requirement that 800 be put in, or are you all?
Oh, I'm sorry, Judge. It's 1,200 each.
1,200 each. Okay. Okay.
Yes.
I know Mr. Byrd was saying he was going to pay another 800. So we're not going to worry about that. We're just going to do 1,200 each.
Yes, Judge.
Okay. All right, and I interrupted you. Was there,
yeah,
Mr.
Judge.
Byrd is going to move out 529. The registry will be split 1,200 each. What else?
And then if for some reason there's not, we will file a notice of non-compliance with the court, but that would be the agreement, Judge, and then go from there.
Okay. Well, let me confirm, Mr. Byrd, is that an accurate recitation of what you agreed to?
Yeah, he just forgot one very important fact. Since most of this case revolves around me not getting my mail on time, he's agreed to, since I don't know of an address right now to give him, we thought it was a good idea for your approving me just picking up a check at the courthouse from one of the clerk of courts.
Okay.
I don't have a physical address at this moment, and a check like that getting lost in the mail, well, we all understand the implications of that.
Why don't we do this, Mr. Gorman? Are you comfortable? Why don't I just have the clerk cut the 2,400 to your trust account, and then you can do 1,200 and 1,200. It'd be much easier for Mr. Byrd just to come get that from your office than to navigate the clerk's office and somebody doesn't know what he's talking about and so forth. Your office is pretty easy to get in and out. Do you mind doing that? That might simplify things.
Yeah, Judge, that's fine. We're willing to do that.
And then Mr. Byrd, so Mr. Gorman, the trust accounts are very strictly regulated. I have 100% confidence Mr. Gorman is going to cut you the $1,200 check. You can just simply pick it up from his office, which is right out here on the outskirts of the courthouse. You won't have to deal with all the courthouse nonsense.
That's fine. I know where his office is at. I just wanted to present an idea, have a check going in the mail.
Yep, that's fine. This way you won't have to rely on anybody's mail. You'll pick it up from Mr. Gorman. Generally, the clerk gets those checks out within a couple of weeks, so don't look for it tomorrow. It will take the clerk a little bit of time, but I will do the order. Mr. Gorman, I've got a pretty handy order that I do, and so in light of the fact that both parties, let me confirm, Mr. Ritchie, do you agree to accept the terms your attorney just outlined for me? You all froze for a second there. Mr. Ritchie, do you agree to the terms?
Yes, I do.
Okay. And Mr. Byrd has confirmed he agrees. He just wanted to make sure how we're going to get it to him so it'll go through. You'll just pick it up at Mr. Gorman, Mr. Day's office. I will do the order then to indicate that the terms are Mr. Byrd will have to 5/29 to get out. You'll have through that day to get out. If on 5/30 you're still there, then Mr. Ritchie can file an affidavit swearing that you have violated the terms of the agreement, and he would be entitled to an immediate final judgment of eviction. But as long as you comply with that deadline, you're each going to get the $1,200, and this eviction case will be closed. So one final point so everybody understands, I'm going to dismiss the case, but reserve jurisdiction to enforce the agreement. So don't misunderstand the dismissal. It's dismissed as long as everybody performs. But Mr. Byrd, if you miss the deadline, you will have an eviction. So just understand that dynamic. I'll take care of the order and it'll go out to both sides. Do you have a question, Mr. Byrd? No. Okay.
Judge, one last point of clarification.
This is fun. Everybody want to smile for the picture?
I don't know.
What's the question, Mr. Byrd?
No, I didn't have a question, ma'am.
Just wanted to take a picture of the Zoom screen.
I was wondering who all these other participants are.
My next hearing, Mr. Byrd. It's my next hearing.
All right. Judge, I'm sorry to take up time, but just one point of clarification. If he is, and I don't envision this happening, but if for whatever reason Judge, we do provide the court a notice of a non-compliance with this agreement, then all bets are off with regards to the funds as well, Judge. That would be litigated at a later date. I think
I can assure you there will be no non-compliance on my part.
Okay, I understand you, Mr. Gorman. The disbursement from the registry, it sounds like maybe what I should do is I can do a couple things. I can hold off on doing the order dispersing until the 29th has come and gone. I don't know if Mr. Ritchie and Mr. Byrd can wait for that money. I can go ahead and put them in your trust account right away, but I don't know if Mr. Byrd is okay with, he's not going to actually get to collect the $1,200 from your trust account until he successfully vacates. I don't know how you want to structure that, Mr. Gorman?
Whether you don't cut the order to disperse or whether you give it to our trust, Judge, I just want that as an incentive to make sure there's compliance all around here.
Is Mr. Ritchie okay with not getting the $1,200 until after the date of compliance?
Yeah, Judge, that's fine. That's fine.
Mr. Byrd, it sounds like that's a requirement. So you understand that I will sign that order. I'll have the clerk disperse those funds. Basically, I'll sign that order on the 30th. Once I'm sure that there's not a non-compliance coming my way, okay?
Yeah, I understand, Your Honor, but I'd like to say that there's really no incentive for me to not comply.
I agree, you know, and I will say this at the risk of jinxing myself, I have had no problems. These agreements have worked extremely well, and I congratulate both sides on working to find something that's imperfect, but far better than the alternative. So I'm not worried about you, Mr. Byrd, and I look forward to confirmation that this is all set, get everybody their money, and get you to start a new chapter with things. I hope this works for everyone, but it's been working great. All the folks who've made these agreements have done very well with them, so I congratulate you on that. Mr. Gorman, anything else I need to clarify from the plaintiff?
No, Your Honor.
I'll take care of the orders then. And Mr. Byrd, anything else I need to clarify for you?
No, Your Honor, I thank you for your time.
Okay, all right, well, I'm 3 minutes late for my next hearing with these other folks, so I'm going to start with them. Wish you gentlemen the best of luck, stay well. Congratulations to your daughter.
Have a good day.
Thank you, Your Honor.
Okay, the 11:30 hearing, thank you for your patience. Pellegrino versus Giordano. Can I get counsel's appearance for Plaintiff Pellegrino? I think you are on mute or you don't have a microphone. I think that's Mr. Morensky. I am not hearing anything. And since I was just in a hearing, I think everything's working okay on my end.
Yeah, I can hear you fine.
Yes, Your Honor. Zachary Zarma here for Plaintiff Paul Pellegrino, and my co-counsel Kevin Marinsky is anticipated to argue this motion, but I did see him attempting to speak, and it was we didn't get any audio. So.
Okay, and we're not going to have any video from Mr. Zerme again. Mr. Marinsky, you got it going?
He gave a 1 moment hand sign, so apologies for the technical difficulties, okay. Your Honor.
He's going to log off and log back on. While we're doing that, I've got somebody named iPhone Can you tell me who you are, please, sir, in the white t-shirt?
Oh, Your Honor, good morning, Paul Pellegrino.
Okay, Mr. Pellegrino is here. And I've got somebody on 732 area code phone. Can you identify yourself, please?
I believe that's you, Tracy.
Tracy Giordano.
Okay. All right. So Ms. Giordano is here, and Mr. Faden is counsel for her.
Yes, Your Honor.
Okay. Just refreshing my memory. And I've got Mr. Morensky with his camera off and muted. Let's see if it works when he turns on. No, but that looks like a very fancy microphone. On the microphone for Zoom, there's a little up-facing caret, and you may just have to select your microphone there. I have made that mistake. No. Heard that.
Okay, is it working now?
It is. Yes.
I apologize, Your Honor.
That's okay. I know everybody's learning, but it is looking like Zoom is here to stay. And so for those of you from other counties, that's probably good news. But yeah, getting these technical things worked out to where you can be seen and heard effectively will pay off, because it's not going away even though everybody's vaccinated. So, all right, we are here then on plaintiff's motion for an order to show cause. And I believe Mr. Morensky, you are going to argue that. I did note that shortly after I can't remember if it was the motion or the notice of hearing, I think there appears to have been a response to those interrogatories. But let me let you go forward, Mr. Morensky, with what you are seeking at this point.
Yes, Your Honor. If you recall, back on April 7th, the court had ordered the defense the respondent to respond to the request for interrogatories that were sent out on December 13th. And the court ordered defense to respond within 10 days. It's been roughly a month since that period. The responses were propounded on, I believe it was May 6th, 2021. But they were also non-responsive. So it's kind of a problem that we're having. And with trial set out a month from now, it's going to be a little bit difficult for us to adequately prepare. At that point, everyone was on notice that trial would be set at that period of time. And it was in contemplation of trial being set 1 month away that the court was giving the 10-day period to respond to the interrogatories. So at this point, we are somewhat prejudiced with trial coming up this closely. Moreover, the responses were not complete.
I'm going to object to that argument even being made today. There's nothing in his motion as to the sufficiency of my responses.
Well, the responses came after the motion. So there is that. I set this very quickly because the trial is imminent and because there was a court order already in place giving a deadline for these, and they had not yet been served. So it's just a May 4 motion. Here we are on May 12 having the hearing on that, but May 6 is when you filed the answers. So I'm going to overrule the objection. I'm going to entertain discussion as to whether they're sufficient. And one way or another, we are going to figure this out and keep this on track for trial. So Mr. Morensky, the objection is overruled and you may continue with the argument. Mr. Faden will of course be able to respond, but we are going to go down that path.
Okay. On April 7th, the court did order from 10 days from April 8th to tender the responses to the interrogatories. That would have given us a deadline of April 19th, by April 19th, April 18th, more specifically. And again, they were tendered on May 6th. So with that being said, we aren't at the point where another motion to compel would be the appropriate remedy here, because there was already a court order ordering the responses to be tendered within 10 days. So we're somewhat past the point of, another demand for another motion to compel the responses. And even if we were to have filed a motion to compel, that would have taken time to be heard, and we would still be prejudiced in preparation for trial. Now, with regard to the responses, the interrogatories were very clear in what they were requesting. The answers the responses rather are somewhat unclear, or excuse me, are non-responsive to the specific interrogatories. It seems like they were just created pretty quickly in response, just directly in response to the filing of this motion for an order to show cause. At this point, I would consider this to be a willful and deliberate attempt to, again, continue in this course of evasiveness, because at the end of, because once the car lease expires, once that term ends, the entire matter is moot. So the plaintiff will not be getting the benefit of this contract that the defense is claiming doesn't exist. So with that being said, I would say that the appropriate remedy here would either be sanctions, would be striking the specific pleadings, and possibly sanctions. What courts have done in the past is, like $100 a day per day that the interrogatories were late following the court's order. I do have case site on that. It's out of a circuit court here. It's out of Palm Beach County, the 15th Judicial Circuit, where that was cited as an appropriate remedy. With that being said, that's essentially what we are requesting, and on basis of this would be through the use of the causal factors in determining whether the violation is willful, deliberate, and whether and in determining what the appropriate sanction would therefore be.
Okay. All right. Well, I want to get some more information on that, but let me invite Mr. Faden to respond to what's been put forth so far, and then we may talk more about if there should be relief and what that should be. But Mr. Faden, do you want to chime in?
I do, Your Honor. And what I'm going to say, I'm just going to proffer to the court that I don't say things like this lightly, and I don't think I've ever said this to a judge before. But I think Mr. Morensky should be sanctioned by you for his statements today. The order of the court says within 10 days from the date of the order, which would be the 19th. My client had her responses to me in time, in a timely fashion. Mr. Morensky reached out to me once from a casino on the Thursday, the 22nd. They were about 3 days late. I discussed with him that I had 2 trials coming up, and that I would like a brief extension to be able to go through the responses my client had sent me, and also I would like him to speak to Mr. Zermay as to narrowing a couple of those requests, because they're just so far from what is relevant to this case is absurd. Mr. Morensky told me he doesn't know if it'll be a problem or not. He would speak to Mr. Zermay and get back to me. The next thing I got was the motion for order to show cause. Neither of them, as proffered in paragraph 12 of their motion that they've reached out to me numerous times, neither of them reached out to me again. And I was waiting on Mr. Morensky to speak to Mr. Zermay about both issues. One, whether I could have a brief extension. I had a 2-day trial with Judge Fowler on the 27th and 28th, and then I had a double jury trial the following week in Charlotte County with Judge Gentile. So that was the reason I said, hey, could I have a few extra days? He said he was going to speak to Mr. Zermay and get back to me. Both of them failed to do so. Anyway, so the next thing, I got the motion, was filed on the 4th. I got it the 5th. I went through my client's responses on the 5th and filed it the morning of I believe it was the morning of the 6th. As far as my answers not being adequate, we can go through those. This is the first I'm hearing it. Again, neither attorney reached out to me and said, hey, your answers aren't good, or we want something else or something more sufficient. I think my answers are pretty spot on for what they're asking. But as far as, I'm sorry, I'm a little angry, Your Honor, as far as number one, Ms. Morensky stating that he was going to speak to Mr. Zermay and get back to me, and failed to do so and continue with this motion and a notice of hearing. And then 2, paragraph 12 of their motion says he's tried to reach out to me numerous times. That was the only contact I've received from either one of them.
Okay. Well, I want everybody to just dial this thing way down, because everybody's righteous indignation is overblown. Okay. This is a county court civil case, and the professionalism has been poor on both sides. Mr. Faden, your indignation is misplaced. This discovery has been in your hands since December. So to trifle with me over a few days and to get all bent out of shape about that is really disingenuous. Your client didn't even think about getting this stuff to you until basically, it sounds like, right up against not Mr. Morensky and Mr. Zermay's deadline, the court's deadline. And the fact that you had multiple trials is not, I'm sorry, my problem, nor is it their problem. And when they didn't get back to you, you should have just filed your answers and gone with it. But the difficulty is when rules have no consequence and court orders have no consequence, we end up in a quagmire here of a lack of professionalism. This stuff was due 30 days from when it was served. And I gave you the benefit of some pretty thin doubts in our last hearing about whether you had gotten the admissions and so forth. I ruled in your favor because, quite frankly, I think an appellate court would reverse me if I didn't. I gave you the benefit of that doubt. I gave you some grace. I gave you some time. And then here I sit on a motion for sanctions. So to say that at the well past 11th hour, there was this dust up that lacked professionalism really buries the lead.
Well,
which
Your
is,
Honor, if I may.
December, sure. Go ahead and interrupt me because I'm having a problem with your professionalism.
I apologize.
Today, look, this stuff has been in your hands since December. I gave you the benefit of the doubt that you didn't have the admissions that long, but there was no debate in the last hearing that you got the interrogatories way back in December. So this is a manufactured crisis, and the trial date's not getting moved. We're going to drill down. We're going to figure out whether your answers are sufficient and should stand and be permitted to be used in the trial, or whether there should be aspects of your side of the story that you're not going to be able to put forth because you didn't comply in a timely fashion. What did you want to say, Mr. Faden?
Your Honor, if I may, at the last hearing, it was at the very, very tail end of the hearing where the interrogatories were even mentioned. It was not fully argued. The court just said they should have been received. I'll give you 10 days from when I submit my order. When I spoke to Mr. Morensky, they were 3 days late, not because of my client. I could pull up her email to me with her answers if the court would like. She had them to me in a timely fashion, and I was 3 days late. And when I spoke to Mr. Morensky, yes, I was 72 hours late. He said, I'm going to speak to Mr. Zermay. It shouldn't be a problem. I'll talk to him and get back to you. And he didn't do so.
Whose problem should that be?
Normally it would be my problem, but if an attorney reaches out to me and I said, yes, shouldn't be a problem, I don't then file a motion for sanctions until I tell him, hey, I have a problem with this, file them right away.
I get it, but I also get that the trial looms large in 30 days and they still don't have the discovery from December. So,
Your Honor.
Is this a good use of our time? Really?
No.
It's not at all. So you have belatedly filed the admissions. I gave you relief on that. You've now belatedly filed the interrogatories, and we're going to see whether I should give you relief on that or whether some or all of them should be cut out. What I want is this: ultimately, a fair trial. A fair trial. The trial's going to stay as it's scheduled. If the belated discovery ends up prejudicing the plaintiff, then I'm going to have to try to figure out how to level the playing field. If it doesn't, then we're just going to go on, and there's going to be potentially no harm, no foul, or potentially at least their attorney's fees for having to run around and get this stuff. It's not their extension to grant. It's mine. You're under a court order to do this in 10 days. And so to create side deals, yes, I get it. It happens. But it didn't work out for you. And ultimately, it was the court's deadline, not Mr. Zermay's. So let's figure out, Mr. Morensky, what quarrel do you have with these answers? We're not going to spend a lot of time on this, but tell me what you think is insufficient, and we're going to either get you an answer or we're going to prevent that avenue of discussion from being used in the trial.
I'm actually going to let Mr. Zermay jump in there more because he'll be able to give more specifically what the objections are to the responses, if I may.
All right, Mr. Zermay.
Yes, Your Honor. In answer to many of the interrogatories,
tell me specifically which interrogatories. We're not going to spend 3 hours on this. Which are the important answers, the answers you absolutely must have in order not to be prejudiced in your preparation, that are insufficient?
So as to the specific numbers, let me see. There's the last interrogatory in particular, I don't have the particular number in front of me because, I wasn't. Anyway, the last interrogatory regarding the request for admissions is key to this case here. because the request for admissions, respectfully to Mr. Faden and Ms. Giordano, they denied basic aspects of the case, like whether or not there was an existence of a contract. And the last interrogatory in particular asks, state all the facts, identify all the documents and all the people that have knowledge regarding anything that's other than an unconditional admission. We need knowledge regarding these denials, Your Honor. The existence of a contract is a basic, just underlying factor of this trial. This isn't supposed to be an aspect of a trial by surprise. And you can't just say, well, we're going to find out at trial what the defense is going to proffer. We need answers under oath to this stuff so we could, formulate a response or try to settle this.
Okay.
So that's the big one that comes to mind. The other ones regarding the particularities of Ms. Giordano's counterclaim, where it says, I don't have them necessarily in front of me, but it says state all the facts, identify all the people and all the documents that relate to your allegations in paragraph, whatever number it is in the counterclaim. They just replied with, see testimony at trial. We can't wait to see the testimony at trial. It's, I hate to use Willy Wonka and the Chocolate Factory as an analogy here, but it's like taking the test before you learn the material. We got to learn the material before we take the test, and the test is the trial. We need the answers here, respectfully, Your Honor. And as to the Mrs. Giordano's one of the interrogatories regarding her assets, that's fine. The answer to that was appropriate, and we're not going to give him Mr. Faden a hard time about that. But regarding the counterclaim and the denials of the request for admissions, yes, we most definitely need those to be flushed out, and we're in the dark, unfortunately, Judge. And me and Mr. Merinsky can't even begin to prepare for trial without knowing what their case is. So, that's plaintiff's argument as to what we're requesting from the court.
Mr. Zermay, before I turn to Mr. Faden to respond, let me ask you, because I don't know anything about the evidence that may be out there, but if, for example, there were an inadequate response, if there's a denial in the admissions and in the interrogatories, the answer did not set forth any names, documents, etc., evidence to support that, then wouldn't you be protected if at trial the court simply prevented defendant from being able to use anything that they had not fully and specifically disclosed under the rules of discovery? In other words, I'm your firewall for trial by ambush. If their answer said there is nothing, or we'll tell you at trial, I'll tell you right now, I'm not going to let them tell you at trial, that will be precluded. Would that address any potential prejudice? If not, why not?
If Your Honor would be so inclined, plaintiff would have no problem with that. Of course, when we're in the actual trenches of trial, it's a sort of back and forth between counsel and all that. And so if Your Honor was so inclined, we would be more than happy to accept that. And if you were to prevent them from testifying as to the particularities of, the non-responsive answers, of course, we would be amenable to that. But we do know that apart from that remedy, when we actually get to the trial, there are specific remedies in place under the Florida Rules of Civil Procedure. It's cited in the motion. One of them is a default judgment, which we specifically asked for in this case, and I think is merited. The other one is striking pleadings. And so there are particular numbers regarding the counterclaims in there regarding the pleadings, and there is that interrogatory that specifically addresses the request for admissions. And so, if Your Honor would be so inclined as well as to just sort of move, I know at this point you addressed preventing them from testifying at trial. A remedy that would really help plaintiff's counsel at this point would be to sort of move that up and say they didn't reply to it at this juncture, so therefore I'm not going to let them reply now, and we're going to prevent them from testifying at a trial because I'm striking that from their complaint and their answer.
Okay, that was a really roundabout way. You're asking me to strike their answer to the interrogatories and not be able to discuss anything that they belatedly contained therein?
Strike the pleadings, Your Honor.
Which pleadings? All pleadings?
All pleadings, Judge.
Okay, well, that's a de facto, that is a final judgment.
It is a default judgment, Your Honor. We asked for a default judgment in this matter. I would think that given the course of the case so far, that it's merited. They simply haven't been playing by the rules. And, you know, you can't have a game unless you play by the rules, Judge.
Okay,
and
but this court is required to address this with a consequence that is narrowly tailored to address the prejudice. So I understand that theoretically I could throw them out of court here today because these have been filed belatedly, but I'm also aware of a fair amount of case law that says, Judge, something short of that would have done the trick of leveling the playing field, and that's what I keep coming back to. I am frustrated that deadlines have been missed and there have been delays. I am committed to a timely trial, and so I'm pushing both counsel to tell me how we can get to that fairly. Now, I think I'm answering my own question. And I appreciate that you basically confirmed this a few moments ago. I think that in order to stay on track for trial and to mitigate any prejudice to plaintiff of the delay in these things coming through, I can simply prevent defense from using anything that they have not set forth in their answer to the admissions, answer to the interrogatories. I know that doesn't punish the delay in filing them, but they were filed more than 30 days in advance of a non-jury trial. And so if I simply prevent them from ambush, prevent them from sandbag, you're gonna have to tell me some other reason why getting them on May 6th makes it impossible for you to go forward with a trial on the merits more than 30 days after that date, before I would even think about something more than simply carving up the evidence in order to balance the playing field. Why should I go nuclear?
Yes, Your Honor, I think you nailed it on the head. You know, that's acceptable to plaintiff if you're amenable to that.
Okay, I appreciate that. And so let me turn back to you, Mr. Faden. Again, I don't know what the parties will present at trial, but to the extent I did see, I think at least one of these answers that seemed to say effectively, the allegations speak for themselves. They'll be proved by the agreement, statement, and testimony and pictures of the furniture that remain. That's 19. 18 is testimony of the parties, the agreement, loan apps, city furniture statements. 20, my responses were not served with this interrogatory. I do not understand what a qualified admission is. I suspect those are the three answers that give Mr. Zermay and Mr. Morensky the greatest concern that there'll be an ambush. Do you want to speak to that at all, Mr. Faden?
Yes, I would like to, Your Honor. In response to number 18, it says state every fact and identify every document and person that supports your affirmative defenses. In number 18, I'm very clear, the testimony of the parties are Mr. Pellegrino and Mrs. Giordano. We don't have any other witnesses on our witness list right now. The agreement is very clear. There's only one agreement in dispute here. The loan apps and the city furniture statements are the only other evidence in support of his non-payment to the furniture. I can't be more clear on that. That's not being evasive.
Is that the same agreement? Did you in fact deny the existence of the agreement in the admissions? I don't know.
Yeah, well, we're denying that it's a valid agreement. We're not denying that that piece of paper isn't there. And we're going to be using that agreement and its terms to show why there was a mistake of fact and why there's an impossibility defense.
Okay, and this is the agreement with regard to the car?
Well, that's this whole case, Your Honor, just a little background to refresh the court's recollection.
Oh, I get it. You don't have to. I'm really
he refinanced the car lease. I mean, that's all that's here. He didn't pay for his half of the furniture. Number 19, I mean, Mr. Zermay did a whole big song and dance, but he's not telling me which questions and what he needs.
Well, he doesn't have it in front of him for this hearing, so I'm not sure why he doesn't, but.
Well, I think he should probably have the document in front of him when he's asking me to be sanctioned.
Your Honor, I have it now.
But see, and part of the prejudice to the court is, I don't believe, I've poked around a good bit, I don't believe the interrogatories were ever filed, not that they needed to be, it's just a notice of service of them. And then there's the response. So I also don't have the interrogatory, at least I don't believe I do. So I have these answers that are disembodied. I don't know whether they might be adequate or not.
Number 18, just so the court's aware, number 18 is identify each denial of a material allegation and each special or affirmative defenses in your pleadings. We don't have any special defenses. We just have impossibility, which he already knows, and it's already pled clearly. State all the facts upon which you base the denial or special or affirmative defense. The names, addresses, and telephone numbers of all persons who have knowledge. Identify all the documents and other tangible things that support your denial. But first of all, these questions are ridiculously compound, and I did my best to answer these. Number 18 is the allegations speak for themselves. My denials, affirmative defenses, and my counterclaim are very, very clear. They're very clear on what I'm stating, and then they will be proved by the agreement, which is this alleged agreement they say they have, the statement and testimony and pictures of the furniture that remain. There is nothing else. I'm not being evasive. That's all. This basically is this agreement, their testimonies, the city furniture statements, and the actual furniture. There's nothing else. And they submitted the copy of the car lease. There's nothing else involved in this case. This isn't being evasive.
And there's no other witnesses besides the two parties. Is that still your expectation?
As far as I know, yes. I have not gotten any other witness list from them.
Okay.
And then number 20, you're asking in the response to the request for admission served with the interrogatories an unqualified admission. He needs to clarify that my client has no clue what that is.
Do you?
Barely. It basically means, and I think it was pretty clear on the denials, it means denial with reasoning thereafter. So, but if he wants that, I mean, it's too broad a question to answer. If he says, you know, in request for admission number 8, you put denied, is there a reason you denied? I mean, I don't know, in an interrogatory, I got to explain my admissions. I mean, an interrogatory is supposed to ask a question and I'm supposed to give an answer.
All right.
I mean, and as far as all the other ones, we outlined her assets, liabilities, who's going to testify to what, you know. I think we answered these as best as I could, given what's in these questions.
Okay. All right. Well, Mr. Zermay or Mr. Marinsky, anything else that you want to request the court to do at this point?
Yes, Your Honor, if I could just briefly reply to the issues with the question to number 20 regarding the sort of asking defense to flush out the denials of the request for admissions. So I think the court is, you know, again, spot on with regards to, you know, what is an unqualified, anything other than an unqualified admission. Well, there's qualified admissions, which are, well, let me explain this a little bit. And there are denials. Those are anything other than an unqualified admission. And we asked them that information regarding anything that was other than an unqualified admission. You know, again, these interrogatories were late and they've denied things like the existence of a contract. We need to know what they're going to say at trial to deny the existence of this contract. These are affirmative defenses as well. We asked them questions about their affirmative defenses and their counterclaims. We don't know what they're going to say. Again, it's a trial by surprise. You know, defense counsel, again, respectfully to Mr. Faden, has said that, you know, testimony that will be offered at trial will prove the affirmative defenses and will prove their cause of action and, you know, conclusively demonstrate that there is no contract. We need to know this at this stage, Judge. Again, it's sort of taking the test before we know the material. Again, this is going to be a trial by surprise. And, you know, Mr. Faden could, you know, write anything in the pleadings, you know, duly pled with the answer, the counterclaim, the affirmative defenses. You know, that's a standard at a motions dismiss. Now is the time for Ms. Giordano to go under penalty of perjury and say, this is my case. This is my prima facie case. If the court is going to take me at face value, this is what entitles me to relief and Mr. Pellegrino to no relief. That's what we asked defense to do, and we didn't get the responses. And now we're less than a month from trial, and
has either party been deposed?
No, they have not been, Judge.
I was actually going to state, Your Honor, if he wants a laundry list of what my client's going to testify to, a deposition is the proper way to do it. And if he wants to depose her, I'll give him dates I'm available.
I think it would probably answer a lot of questions if you all just did depositions. I understand what you're going toward. And unfortunately, I don't have a better answer for you than to say, we've got 1 day set aside, June 9th. And I don't think it's going to take a lot of time for the testimony of what happened to be put out there. And I think I'm probably going to spend a good bit of my time figuring out whether I should exclude defendant's ability to put forth certain testimony or evidence if they were unduly vague in their discovery answers. I think that's an appropriate use of the court power to keep, like I said, the playing field level. You answered it vaguely. We'll see whether that proves to be adequate depending on what's going on. It's not a jury trial, it's a bench trial. But we're pretty far in the weeds at this point, and I think ultimately you probably could have done a 30-minute deposition of each of these parties and had an idea what their position is and how this trial is going to go down. But I think, didn't you guys already mediate unsuccessfully? So there's just been a lot of wasted energy here, and there's a lot of fighting about the fight. You got my full day, June 9th. I'll pick through all of it and decide whether the defendant should be allowed to put forth their evidence or whether they should be appropriately blocked from putting it forth because they hid it in the way they chose to answer the discovery. Certainly there's at least some possibility I'm going to be shutting down some defense testimony because, a one sentence answer that says, well, my testimony will tell you it's not an answer to an interrogatory.
Well, Your Honor, just to clarify.
Die by the sword.
Your Honor, just to clarify, he asked what evidence we're going to provide. My answer was the testimony of the parties. It wasn't.
I believe the question was, what are the facts on which you rely? And
the testimony of the parties.
I rely on my testimony isn't really an answer to what are the facts on which you rely. So we can have this fight on June 9th. I'm already looking forward to it. If you want to give really short, vague answers after deadlines, I hope that you have disclosed what you need to disclose in order to put forth what you need to put forth. But if not, I'm the firewall on that. You don't do trial by surprise, and I'm assuring plaintiff I won't permit it. And so to come in on the 9th and say, well, Judge, that's what we meant by my testimony. If the question was set forth the specific facts on which you plan to rely, and you said my testimony, that's probably not going to be a lot of testimony. So if y'all want to try to organize a couple of quick depositions by Zoom between now and June 9th, I think that'd be a great use of your time, because I think it may be that the two sides are teeing up a bad use of their time on June 9th if you haven't really engaged in meaningful discovery, and instead it's just been gamesmanship and subterfuge. I don't know if it has, but those aren't the most impressive answers to interrogatories I've ever seen. And to blow the court's deadline and getting me those answers, I tell you, that tells me what I've got to look forward to on June 9th. But I'm not going to allow a trial by ambush. I assure the plaintiff of that. So I don't know if we need an order from today. I'm not striking pleadings. I'm not entering a final judgment, but I am assuring plaintiff that what has been delivered under the rules of discovery is going to be the gospel under which this case will be tried. And if there wasn't a clear answer given, I'm not hearing it at the trial. So do I need an answer to that effect, an order to that effect, Mr. Morensky or Mr. Zermay? You want to prepare something, or have I given you enough information and you all just go forward and prepare based on what you've been given?
I think there's enough that's on the record.
Mr. Faden, anything else I can clarify, or anything that you would ask the court to reduce to order at this point?
Well, the only issue I have is Mr. Zermay gave a very, very broad idea of what answers he finds insufficient. He didn't say specifically what answer and what he's looking for that I did not provide. I think that's necessary.
Tell you what, I'll ask Mr. Zermay and Mr. Faden, file in advance of trial, motion in limine to exclude anything you think is excludable. I'll address the motions in limine at the start of the day, June 9th, and we'll see what everybody ends up having to work with. But for sure, those last three answers, right above that looked like some relative specificity, that there was property, there were prices, there were accounts, and so forth. But I think we're definitely in a red zone when the answer to an interrogatory is my testimony. But let's flesh it out with a motion in limine, so you at least know what they plan to object to. It's like this philosophical debate. Well, I don't know what I'm going to object to because I don't know what you're going to say. Well, I don't know what I'm going to say because you didn't ask me. Well, I did ask you, you just didn't answer. And we'll have that on June 9th. I don't get this normally, guys. I'm sorry if I don't, if I'm not behaving the way you want me to, but I can tell you, I work with a lot of lawyers, and this isn't the behavior I ordinarily see. I see agreements, I see quick movements, I see detailed answers. So I'm not sure where the blame lies. I don't care. I'm getting the case tried on June 9th. We're getting an answer for these two hapless individuals who are trying to get to the bottom of their dispute. But a lot of this could have been avoided. A lot of this could have been avoided. A good faith mediation would have avoided this. But the lawyers want to fight about the fight, and that's expensive for the parties. But we're going to bring it to an end on June 9th. So with that, I will wish you all well. File motions in limine if you think there are things that should be excluded at trial. Take depositions by Zoom. You could do a deposition by Zoom by the end of the week. Get that done. Figure out what the facts are going to be. And if you've really got a bona fide dispute here that's going to be worthy of a day of your time and a day of your client's money for that time. And if not, let's figure this thing out. All right. I hope, I don't know if I've been helpful, but at least you all know where I'm coming from. I'm not getting in the weeds, and I'm not playing games. All right. So with that, I'll end the hearing, and I will look forward to any other motions. Any motions filed at this point are going to be heard at the trial.